All right, folks, welcome back to MEA 425, the second part of our first week, second presentation of our first week. We'll be continuing to respond to the question, what is copyright, by looking at what copyright owners do. And so, how do we understand copyright ownership? Um, how song recordings are they are copyright, but they are different enough from all of the rest of the kinds of things you can copyright, like a photograph, poem, book, movie, etc., that they should be understood in their own way, especially given the importance of sound recordings to our area or our areas. Registration. So, when should you register? How do you register? Why should you register? This is federal registration, which we mentioned is not required in order to receive federal copyright protection. But there are some extra benefits to that. We'll get into that. And then this really interesting wrinkle in U.S. law, which is the ability for songwriters or authors, I should say, to terminate a transfer of copyright and to recapture their work. Okay, so without further ado, let's jump into the fun. I want to use the 1976 Copyright Act as a way to, get us back into to review from the last presentation. You'll remember that the 1976 Copyright Act was the first major piece of legislation after the 1909 law. So, Copyright Act is not something that gets modified or addressed very frequently. So that's 60 plus years. We've had the Music Modernization Act, 2018. That's another almost 50 years. So when it happens, it's significant. And so the 76 law is really the one that created the standard version of the music business that we've come to know, or the media and entertainment business, to the degree that it depends on the integration of music that we've come to know in the quote modern era, right? So the second half of the 20th century to the present day. We will, of course, talk about the Music Modernization Act of 2018 in due time, but let's lay the foundations first. So we've got the bundle of rights. You should be able to remember 4 Ds and a P by this point in time. Great moments from the bundle include distribution, duplication, derivatives. Can you think of the others? How about the right of display? And of course, finally, the right of public performance. Now, what do you do with Circle P, right? So the right to the phonorecord, the sound recording itself, also known as the audio master. Well, in 1995, they added the distribution of Circle P as a sixth right. So the digital DPR, Digital Performance Right in Sound Recordings Act of 1995, did kind of go back, as law tends to do. You've got this big act, and then they'll go back and be like, well, we need to modify it and sort of streamline it. And then after you get enough of those, it's like, well, let's just make a new act. So another thing that's important to remember about the 76 Act was that it made term, or how long copyright protection lasts, based on the author's life. Okay, so before the 76 Act, which goes into effect in 78, by the way, copyright was just a matter of an initial term and a renewal term. So whether it was 28 plus 14 or 28 plus 28, however, based on where you are in the timeline, that's how things were before 1978. In 78, however, because of the 76 Act, they said, well, let's make it based on however long the original author is alive, and then we'll throw in a bonus 50 years for the author's spouse or family, children, etc., to also enjoy in the importance and success of that original author's work. That original term was modified with the Copyright Term Extension Act, also known as the Sonny Bono Law. Sonny Bono, the famous or infamous husband of Cher, was also a senator, I think from Nevada, passed in a tragic skiing accident. But in any case, before he did, he changed it to life, or he spearheaded a law that changed it to life plus 70. And so that's what our current copyright term is. How long is your work protected? Your entire lifetime plus another 70 years. Pretty good deal. It's almost like 2 lifetimes. Now, what's interesting here is that you're having a law that bases copyright protection on a human life, but not all works are owned or authored by humans. How can you have a work that is not authored by a human being? Right? And so the way that works is copyright language, or I should say actually a contract language, where you've got, a record company or a music publisher that has a little clause in their contract that says, the work that you do for me is what I'm paying you to do, and so you're my employee, and so whatever you generate, whether it's a song or a record, that is to be considered the reason that I pay you. And so the ownership of that work belongs to me, the company. And so when a company owns a work, and that language, by the way, is called work for hire. So you're hired to generate this work, and the ownership or the authorship, I'm considered to be the author as the company. And so now you're in this weird situation where a human being, you can't base the term of protection over the lifespan of a company, because companies are potentially immortal, right? Based on who has the primary ownership of that company, stocks, etc. They can go from hand to hand to hand and just continue until they basically go bankrupt. And so when you have a work for hire, it has its own timeline. And we'll get more into that. But just so you're aware, the timeline for a work for hire is that it's protected for 120 years from the time that it is created, or 95 years from the time that it is first published, whichever one of those two lasts the longest time. Right? So you've got about 30 years, 35 years after you create a work to publish it before the second window, the publication window, becomes a longer one. All right, back to the bundle of rights. Okay, so now we're talking about ownership. Okay, so this is really important. So we talked about this before. The 4 Ds and the P are over to the left-hand side. Those are the rights that copyright owners have. So they have the right of duplication, distributive, derivatives, display, etc. And so anyone who wants to use a work, right? So the use is any user of another person's, another owner's intellectual property. I'm in the middle here. So any use of another person's intellectual property, like a record company that would duplicate a song and distribute those copies, right? That license would be referred to as a mechanical license. So mechanical license includes the rights of distribution and duplication. If you go down to the yellow here, derivatives. So this is a new work that's based on the original. So the copyright owner has the ability to approve and say, you want to make a play out of my book? Sure, but I'm going to make you sign this rights deal that tells everybody how much you're paying, how long you can use it for, can you use it in these different kinds of media, where can you use it, etc. And so that typical license is a rights deal that is based on the right to make derivative, so a work based on the original work. Display is the right, and a sheet music publisher needs to sell sheet music, so they are making a visual version to display a song or the lyrics. If you have a book of lyrics, you've got to have rights to use those lyrics, and so the typical license there would be a print license. In the case of performance, the right of performance, important to remember that performance is understood not just as a live performance like a concert, but also anytime that a song is broadcast over public media, that's considered to be a performance as well. And so public performance licenses would be the typical mechanism that transfers that right to the radio station, TV station, concert venue, etc., so that they can use the music in that way. Okay, so I'm expanding now on this idea of how the bundle of rights ends up being expressed in music publishing and licensing as these typical license types. This is certainly not all of the different licenses, but these are some of the core licenses. So takeaway points at the bottom of the slide I want you to remember is that the music publisher is the one designed to exploit all of these revenue streams. Okay, so mechanical licenses, rights deals, print licenses, public performance. By and large, the music publisher is the one who is in a position to say, okay, I've got this piece of property. How can I exploit it? How can I make the most money out of it? How can I place it in all of these different media areas so that I make the most money and the original author also makes the most money? So they're like a team, right? The publisher and the original author usually have an agreement. They're in business together, right? For the business. They don't have a business, but they do have an agreement, a contract. And the name of the game here is to place this property, intellectual property, song, in as many different types of media as possible. And so the license down here at the bottom is the legal agreement that structures the flow of rights, right? So the license says, okay, I'm going to let you, record company, the license transfers the rights to the record company in exchange for royalties that flow back to the publisher and the songwriter. Okay, so just try to get that basic concept imprinted in your mind, because that is the sort of beating heart of the music business when it comes down to copyright and licensing. So I want to make sure that everybody has that, because we're going to take this little seed, and this is the common ground that we're going to build this class out of. So it's really important as a foundation concept. Okay, let's talk about Circle P, because none of this really, I should say that not none of it, but I just kind of went over the fact that when the record company takes a mechanical license to, take the composition as a song, and then to get an artist in the studio to perform it, and then they get this recording, that recording is enabled, right? It's enabled by the mechanical license, but it becomes a new form of copyright. And Circle P doesn't really belong to, it's still federal copyright. It's federally protected, subject to exploitation for money and licensing and the rest. But not, how are you going to display a recording? How are you going to, make derivatives of a recording, right? It's possible, but it's definitely its own sort of bird there. So let's talk a little bit about sound recordings. Okay, designated by a new symbol, P with a circle around it, instead of songs, which are C with a circle around it, along with photographs and basically every other form of copyright. So it really is its own thing with that P with a circle around it. Federally protected as of 1972, which means that pre-72 recordings were in a bit of legal limbo, and that's one thing that the MMA, the 2018, the recent law update of the 1976 law has addressed. You'll remember that in order to make a record, you've got to record something, and that something is a song, right? And so you're recording a song. The song doesn't belong to the record company, but the recording will. And so they're in a position of needing to license the song in order to create their own copyright and then become their own copyright owner. Okay. Which license is required for a record company to do that? That is the mechanical license, and it confers the opportunity to duplicate the song and then distribute those duplications. So records themselves, CDs, vinyls, streams, whatever. It's a mechanical license at work there doing that. So you can't display it really. You can't make a work based on. You know, it has a limited distribution right. And so how does the phono record actually make money? So it has some exploitation rights of its own. The first one is the doctrine of first sale, which simply says that, you know, if I buy a CD or if I'd buy, you know, an old vinyl record, and then I can, you know, am I prohibited by law? Like, is it illegal for me to then turn around and sell it to my friend? No, right? Obviously, I can. People sell records on eBay all the time, or CDs or whatever. But it's that very first sale that is protected by law. So that money from the first sale goes to the record companies as the owner of Circle P, right? And that was originally all that copyright law had as a law, which is just a doctrine. It's kind of a, you know, hey, wouldn't it be a good idea to recognize this type of a law? That was the only way they had to fight digital, you know, piracy. Was, all right, we don't, you know, the doctrine of first sale is being trampled upon. So the you know, the federal sort of legal response to piracy was slow, because the doctrine of first sale is not a very powerful law. It's something that's recognized and accepted, and so it didn't give a lot of teeth to anti-piracy, you know, in the circa, you know, 2000. Another way that Circle P makes money is what's referred to as master use. And this is the primary way outside of digital performance rights, which are growing. So master use is using the entire recording. So a movie producer who wants to use a song, not just the song, but a specific recording of a song, because it is part of this time period. You know, we're going to do something from the early 1970s. So it's not only important to have this song that was written by the Doors or Pink Floyd, but we want to have the actual recording of that. And so now they're having to turn around and say, okay, we're going to go to the publisher to clear the song, and we also have to go to the record label to clear Circle P. And those Circle P licenses are very expensive. To give you an idea, you know, when the Beatles, you know, lost their rights to their publishing catalog, I think Michael Jackson had them for a while, around the time that Nike tennis shoes and athletic wear used the song, the Beatles song Revolution, for one of their ads, one of the first and only times that a Beatles song and master recording were used. I think it was $500,000 for a year to do that for the master use. And so it's very expensive to do that, but that's how it works. If you just want to use a teeny piece of that recording, then that's going to be a sample, right? Sampling license. You've got like the Amen drum break that's used in a lot of early hip hop records. Different bass lines, stole from like Parliament and Funkadelic, not stole, but borrowed from, and so sampled. Right? We're going to sample just this bass line, just this drum break. Okay, that's another way that sound recordings can make money. And then, of course, digital performing rights. So when webcasters or streaming services allow for or use, you know, broadcast or publicly perform a recording, then they also, you know, that triggers the performing rights. So a piece of money, royalty, comes from those users, Spotify, for example, and goes to the record company who owns Circle P, as well as the publisher that represents Circle C. Okay, so Circle P and Circle C are kind of parallel copyrights that run through a lot of the music business. If you want to use the original recording, so that's Circle P. If you want to save some money and not use the original recording, then oftentimes producers will bring in another band that can sound just like the original artist, and then they only pay Circle C and then pay the band, this cover band, um, a smaller, nominal amount for the performance, and that's what's referred to as a sound alike, right? They sound just like the original artist, so they create a sound alike recording, and that way they step around, or they basically have more control over their budget. All right, so let's talk a little bit about registration. Okay, I mentioned, so copyright registration, you don't, as an author, have to federally register your work in order to have federal copyright protection. You'll remember, as soon as you do the 3 requirements for copyright protection, you are magically, boom, you're protected. However, people still elect to federally register their works with the Copyright Office. And so why would you do that? Well, basically, if you're anticipating being in court. When do you anticipate being in court? Well, if there's enough money circulating around what you do, enough visibility, if you have a certain, national or international visibility or status as an artist, that implies that you make a certain amount of money. And anytime you have that implication, you're perceived as being successful, then other people want a piece of that. And they will find ways to get you in court and roll the dice to see if, there's going to be a payday involved. So, that's a little bit of a dark spin to put on it. Not all court cases, lawsuits are frivolous the way that I described that, but that definitely comes with the territory. And so you're established. The chances of ending up in court in a copyright case are just going to go up. That's the fact of the matter. And so, why would you do that, right? So what exactly does federal registration provide to copyright owners that helps them have a stronger position in court? Well, if you register within 3 months after publication, then you can sue for attorney's fees, right? So, which tend to be very expensive. Usually, just getting this, since it's a federal law, it's a federal case, go to federal court, you're talking about six figures just to get the case sort of launched off of the ground. $250,000. A big chunk of that is going to be legal fees, and so the ability to sue for that, so that if you win, you can have the other side pay for your legal fees. There's a lot of incentive there, obviously. If you register within 5 years of the publication of your work, then you have what's referred to as prima facie evidence. All that means is that you are the presumed owner. The copyright is presumed to be valid, and you are the presumed owner, which means that the burden of proof shifts to whoever's challenging you in court. So they have to show, it's on them to prove that you're not really the owner, or that you got it from them, or whatever the case may be. So that's also a strong position, because the burden of proof is on them. They have to do more work. And so that's how being a federally registered, having the certificate, comes on a little piece of paper from the government with a Circle C or a Circle P. That's how that protects you. And so back to our questions then, why, if you're established, you want to get, federally register your works. When? Basically, the sooner the better. Between, 3 months to up to 5 years, you get some benefits there. Okay, how do you register? The first thing you have to do is go to uscopyright.gov. You Google that, it'll bring you to the homepage of the Copyright Office, and you've got 3 choices. You can use the old paper method, which they are dissuading because it's the most expensive, almost twice as much as electronic filing at a $60 filing fee. You can do a hybrid form where you fill the paperwork out online and then print it out and then you mail it in. Or you use the e-copyright or the electronic form, which is $35. And um, there is no paperwork involved, right? So you choose your method. You should notice that the paper has a lot of forms that the electronic form kind of streamlines. So the old paper forms include Form TX for textual or literary works, VA for visual arts, PA for performing arts, SE when you're just going to have one single title or work, or you can do group works. The cheapest you can do this deal is $35 and do everything you did in 1 year, copyright protected. So works of Paul Linden 2020, I could do all the songs that I wrote, which unfortunately aren't as many as I would like, but I could copyright them as a group for $35. That's the sort of fast and easy way through this deal. Then you complete the registration. The only ones who can do this would be the authors themselves or the claimants. And so if the right of ownership has passed down, if the author has passed away, it goes to their spouse or children, they can be a claimant or a licensee, an exclusive licensee, or a publisher, someone who's had the work transferred, the copyright in a work transfers from a songwriter to a publisher, then they have that ability to complete registration as well. You pay the fee, as mentioned above, and you make the deposit. So this is particular. So the deposit basically can be a physical or electronic version, depending on what kind of work it is. And so usually for sound recordings, they want a physical version, but not always. And so right now, the standard is to submit a physical CD as the best version of your record. But so the deposit just means the best possible version of whatever the work is itself. So you pay the fee and you submit the work so that they have a copy of it. It may be one copy or two copies, and then you wait, right? So it may take as fast as 6, but as long as 18 months for this to turn around, and you get the registration, proof of registration back in the mail. But registration, actually kicks in as soon as the Copyright Office receives all of the requirements. And so it's not as if you have to wait the full time to get the registration in the mail and then you're protected. So that's the how of it. Stepping back and looking at the relationship between authors and publishers, which is kind of what this class, it's like the core of this class here. Publishers and authors, as I mentioned before, are like a team, quote, in business together, but they have an agreement, a songwriting deal in the case of the music business. And so songwriters in that example would be the authors, right, of the song. They assign their rights to publishers who then become owners of those songs for however long the deal is good for, right? And by being the owners, that motivates them to, get these things out there. So they place the music, which means to license or to exploit, to get the most out of them that they can. And then typically they'll split whatever they get 50-50 with the songwriters. And so that's the kind of skeleton of the songwriter deal, where the publisher, why the publisher and how they fit into the deal. And they're the ones that are, looking to get placing the songs at all of those different levels. And so what do you think? Let's have a quick review here. Can publishers register the songs of the agreement for copyright? What rights do songwriters have after assigning to the publisher? They've given up their copyright to the publisher for however many years that deal is good for. Do they have any rights? Okay, the second question we haven't answered yet. I'm just interested in your assessment. The first question we have answered in the previous slide, you'll remember that authors, claimants, and exclusive licensees can register for copyright. And so publishers are on that list. Publishers oftentimes register works for copyright. That's part of what they do. But what rights do songwriters have? So this is the last little section here. A really interesting little wrinkle in U.S. Copyright law is this termination and recapture bit. So it's provided by the 76 law. It's completely unique to U.S. law, so there's no point in trying to, pursue this idea for international, an international sort of sphere. But basically, it's a right for authors. So, in the case of music business, I'm sliding in songwriters into authors, but it's a right for authors to reclaim and to their copyright. So if they've transferred a copyright to a publisher, then termination recapture offers a window of about 5 years for songwriters to be like, you're not doing anything, you're not doing enough, I'm going to take this property back. And so it's a 5-year window of eligibility for authors as long as they give notice between year 25 and 38 after transfer. And so we're talking about long amounts of time. So that lets you know how, how these deals work. Usually songwriter deals with publishers are for the life of the copyright. And so that's why these time frames are so long. Pre-77 works are on a different timeline. The 5-year window extends basically at the end of the 28 plus 28 deal, so 56 to 61st year. As long as they give notice in time, which is usually the decade prior, then they have the right. Songwriters have the right to break that deal with the music publisher and basically assume that position, so they become the copyright owners again instead of having transferred that ownership outside. Okay, let's see what you remember. Can you recite the bundle of rights? For what and a what, right? So it's 4 Ds and a P. Derivatives are one of those. What is a work for hire, and how is it unique compared to traditional copyright? Copyright deposit, what does that mean? Is that talking about money? What are we actually depositing here? What's the difference between Circle P and Circle C? And what is referred to, what do I mean when I say IP exploitation? What is IP, first of all? So that is intellectual property, and exploitation is the effort to capitalize or make money off of intellectual property. So IP exploitation is fancy talk for what a publisher does, right? Placing songs, which are intellectual property, into the hands of different users, film, TV, advertisement, print music, radio, on down the line. So they're trying to get different producers to use these songs, give them a license, and then get the rights transferred to them for their particular use, and in exchange for that, the royalties come back out. Okay, so that is our second and final presentation of the first week. You will need to make sure that you go grab the assignment number 2, which is the timeline. Use the first presentation to look at the timeline and fill out those dates of what happens when in the history of United States copyright law. Good luck to you. Please let me know what you thought, what was clear, what was unclear. Use the comment section to say hi, and let me know if you have any questions in particular. Thank you very much. See you next week.